Thank you so much for that introduction. My name is Matt Meadors, Chief Operating Officer of HOA Organizers.
And I am Maria Kao, partner at Briscoe, Ivester, and Bazel LLP.
And today we are going to be talking about how to keep your HOA out of court. Very exciting. Litigation can harm a community in a variety of different ways, whether it's financially, the association's ability to get insurance, the ability for members to sell their homes or refinance, and something that I think is not talked about a lot, reputation of the community. So this can be the ability for the association to get vendors, management companies. Maria, you can speak to this, even perhaps legal counsel.
Yeah, don't be the hot potato.
So today we're going to be talking about three main things. The first is communication, what you say and how you say it. The second is going to be documentation, the records that you maintain and how they are distributed to the membership. And the third is going to be pre-litigation and administrative tools that you can use to cool the temperature once things come to a head. So the first category we're going to be talking about is communication. So this is written, this is verbal, and this is conduct, the actions that you take. An important thing to remember is that board members are representatives of the board of directors and also the corporation. So conduct within the community while you're out and about, as well as within structured board meetings, are communication. This includes interactions with homeowners, vendors, management, guests at the community. All of this is communication. An important thing to remember is that executive session discussions are confidential. So if you have a friend in the community that you've been friends with for 30 years, and there is something that the board has discussed that could be disadvantageous to them, really important to remember that you can't share that outside of the board meetings. Discussing litigation strategy with any of your nosy neighbors who are interested in the goings-ons, not okay. And perhaps going into detail about a medical condition that allowed a certain reasonable accommodation request to be approved, also something that you cannot disclose. It's also important that board members are speaking with a unified voice. If the board of directors has made a decision, an individual is not allowed to go out and discredit that decision or say, well, it wasn't my decision, that was the others. Really, really important that the board speaks with a unified voice. The other important thing is that board members cannot act unilaterally. There may be some situations in which a board of directors authorizes a board member to take certain actions or spend certain money without going to the board for a vote. But if a board member abuses that privilege, then the board can pull it back. So it's really important in all of this to get attorney guidance as you're going throughout your day to day to make sure that you're still in compliance. So, Maria?
I really like what you said about how the board has to act as one team, one voice, and that they should take care not to undermine each other, especially publicly, because the decisions are for the benefit of the membership at large, and it's one corporation. Can you tell me, Matt, since the managing agent is in charge of the day-to-day and the attorneys aren't always there, at what point do you see issues arise where you feel it would be important to tap in the association's corporate counsel?
So, for instance, if there were ever a situation in which a board member did start to act unilaterally, either authorizing contracts or speaking negatively about the board as a whole, or just kind of taking matters into their own hands, that's when we want to go and get counsel so we can figure out how to kind of rein that back in. But I think even before that, it's really important that the association's counsel is contacted whenever you're looking at putting out correspondence that could be shocking to the membership or otherwise disconcerting, as well as have your association's council meet with you for a board orientation every year just to make sure that everyone is on the same page.
Would one of those shocking topics be parking?
Surprisingly, yes, that is one of the shocking topics.
Speaking about parking, it's usually regulated by processes and procedures. Do you have something to say about that in terms of communication?
Yes. So, with all of your processes and procedures, ambiguity is the enemy, right? We really want members to know how to succeed, what the expectations of them are, and how to live harmoniously in the community. The primary way that we communicate these expectations is through the association's governing documents. So, Maria, is there a reason why associations may want to restate or amend their governing documents?
Yeah, I mean, I hate to say it's as generic of an explanation as they're just too old, but the reason is some of the older governing documents are just a lot more bare and they don't outline what's required of the membership and the association with the amount of specificity that we need now. And also the code has changed a lot over the past few decades. And, sometimes the older documents intended certain things, but by operation of code, now we have to do things a different way. And so, to that extent, if you're looking at your documents and they just don't serve you in terms of governing your membership, it would be time for you guys to revisit whether a CC&R amendment or restatement is in order, or some other change to your other governing documents.
Yeah, so some of the other governing documents, maybe things like rules, just the general do's and don'ts of the community. Pick up dog poop, don't make so much noise. And what the ramifications are for not following those, like a fine schedule or other, actions that the board may take if someone doesn't follow them. Policies. So this can include things like harassment, things like board conduct. What are board members supposed to be acting like when they're in board meetings? And water intrusion, which is something that is rarely spelled out with enough specificity. Who's going to be filing insurance claims for what? Who's ultimately going to be responsible for replacing or repairing your antique couch? And the timelines with which all that must happen. The other thing that I have found really, really useful and generally something that your attorney can draft for probably less than $1,000 is a maintenance matrix. Um, just a general T chart of physical components out the community and who is responsible for maintaining, repairing, and replacing the members or the HOAs. So this can be a really cost-effective manner rather than kind of altering your governing documents to just clarify who's responsible for what. You also want to make sure that your architectural procedures are standardized. So this includes the architectural applications and guidelines, landscape guidelines, so who's responsible for maintaining, watering, trimming, especially new plantings. Windows and window coverings, if you're in single family homes, painting guidelines, what colors, can they all be the same or do they have to differ? In condo communities, soundproofing for flooring installations, very important. And hopefully by explaining those at the front, you can avoid the pain on the back end. A few specific ones that I just wanted to call out are electric vehicle charging and solar panel installation applications, because there are specific sections of civil code that talk about when the association has to either approve or deny the application. So, Maria, can you talk a little bit about the, I guess, timing of those particularly?
Yeah, by code, you have to consider the application for the EV charging within 60 days of receipt, and then on the solar panels, 45 days. But more importantly, on those two specific policies, and I've seen boards do this, they cannot deny the request. You can impose a reasonable restriction around them, but these two particular requests for improvements are really complicated in that, maybe you want insurance from the vendor, maybe you want indemnity from the vendor, maybe you want a right of inspection before, during, or after the thing is being installed. Maybe the solar panels are on a piece of roof that's going to be shared by other members, and you have to guarantee those panels are laid equitably. This is probably one of those policies that you do want to get in order before anyone even makes a request, because that's just not a sufficient time frame for you to investigate your own common area and see whether the application is feasible.
Right. And I mean, even if you received an application, didn't have any kind of policy in place, the timeline for implementing a policy that you could use is, you'd be down to like, I don't know, 15 days or something that you'd have
Yeah,
to
I mean,
figure it out and
right,
make a
you get the
decision.
application and then you give it to the attorney and God forbid it's a black hole in there. And then before you know it, your deadline is up.
Yeah, exactly. So the idea is to get it in place before it even becomes a question. Um, The other thing we want to talk about with communication is to be mindful of tone and the why behind it. So it's really important to remember that these are people's homes. This is where they live and lay their head at night. This is what they're going to pass down to their children, their legacy. It is inherently emotional, and to think otherwise is foolhardy. So we always want to think about if we were on the receiving end of this correspondence, not having the knowledge that the board of directors has, what would we want to know? And it usually boils down to one question. Why? Why do we need a special assessment? Where did our reserve funds go? Well, it could be from years or decades of deferred maintenance that ran up the cost of doing necessary repairs. It could be unexpected new laws with new expenses, such as the balcony bill. It could be an insurance market that has gone haywire in California. But there are reasons for it. Why can't you tell us what you're doing to make this member stop violating the rule? Maria, are we allowed to tell people that we have fined them and that we've taken away their privileges? Can we disclose that?
No, you really shouldn't be talking about other people's violations or anything like that. I mean, thankfully, the association is obligated to maintain the privacy of individual members. And I know, particular inquiring minds want to know, but, I think that those members, if it was them that was at the target, they would appreciate that kind of discretion.
Yes, absolutely. And my favorite, I don't know if anyone else has gotten this, why can't we make the community park a jousting field? Well, a couple of reasons. One, there's a bunch of insurance ramifications to doing so. And, the board may have discussed the ongoing cost of horse maintenance and just decided it wasn't in the best interest of the association. So the main thing you want to do is be sure that you're outlining the benefits and maintaining positivity in the correspondence that you put out. So, of course, some things may cost money, but it's either protecting the association from costly litigation down the line, or it's preserving property values, which is what we all want. You also want to be mindful of what information you cannot share. So, just as Maria shared, there are certain things that are confidential and the board is not allowed to disclose. Um, there are surprisingly a lot of things that you can disclose, but you always want to check with counsel to just be sure that you're not saying anything that you ought to. If you're unsure, check with your attorney. um, and then it's often not what you said, but how you said it. Maria, I know you talk a lot about determining whether or not correspondence should come from either the managing agent or the board of directors or from the association's attorney, and how that can affect how information is received from the various entities.
Yeah, I definitely agree that there's a time and a place for the attorney to get involved, but oftentimes it's not the first notice to the member. Um, you know, I could be drawing hearts and sunshines underneath my letterhead, but the fact that it's coming underneath my letterhead is intimidating. Okay. All of a sudden, you're getting some letter from the attorney, and you may not have known there was anything wrong. And all of this formal legal jargon is overwhelming to the average person. Um, you know, as an attorney, I get lawsuits on my desk all day, every day, and it's not intimidating or scary for someone like me. But if you're not accustomed to that, if you're not a lawyer, to get a letter from an attorney is really increases the volume on what that dispute looks like. And so my first recommendation is always, well, did you send out an initial notice from either the management company or the board of directors? Have you had some informal conversations, some emails, some inquiry just before you get to the point of, having me get involved? Because even where it's coming from has an impact on what that communication is going to or what that communication is going to appear as to the homeowner.
Very true.
Okay.
Documentation.
Yeah, so, it's really boring to talk about maintaining the association's records, but it's also really, really important because as a corporate counsel for associations, I'm seeing a trend, an uptick by the membership on getting document inspection requests. And sometimes it's not necessarily because the member wants to see something in particular. They're not actually interested in anything in the association's records. And sometimes this inspection request is a result of, well, I'm mad at you, so I'm making an inspection request for everything that the association has since its incorporation from 30 years ago, right? And as you can imagine, it's really time consuming and expensive, and the association is limited in what it can recover in terms of cost for production. However, if the association's really good about its documentation, everything is in the homeowner portal and they can look at it whenever they want. It's really easy to meet those demands, and it really diffuses the situation because maybe they are looking for something in particular, but if you kind of ignore their entitled request, then their mind goes often to the wrong place, which is you're definitely hiding something. You're definitely doing something, and it really raises the temperature as opposed to reducing it.
100%. So a couple of these records that we talk about are things like minutes, resolutions, financial records. So again, some do's and don'ts, right? So minutes, meeting minutes, we want to keep it generally to decisions that are made and not necessarily discussions that were had. I've seen minutes where they will outline everything that was said by each member who was in attendance during open forum. It really puts the association in a tenuous spot, for a variety of reasons. So they are records of decisions. Um, Maintenance records. So if you ever go to file an insurance claim for a leaky roof or something that has failed, a major physical component, one of the things that the insurance company is likely to ask you for are your maintenance records. How have you been maintaining this physical thing? Similarly, with litigation, people want to know, has the association been doing its duty to maintain these things? And then also reviewing your financials monthly is super important. Your managing agent or financial manager should be providing these to the board of directors. And Maria, correct me if I'm wrong, but there is a section of civil code that requires that board members review specific financial reports.
I'm nodding yes.
Yes, I see. um, Contracts, warranties, insurance policies of the association and the vendors that it contracts with. So really, really important that if you're entering into a contract, frankly, no matter how trivial, right, or how unnecessary you think it might be, it is always best to run this by your association's legal counsel, just to make sure that you're not falling prey to anyone who is just trying to protect their own business interests, right? But may, in doing so, be potentially harming the association. Um, so, um, and then it's also important to remember that everything in writing may be discoverable. You do have some protection when you're talking to your association's attorney, but these are things like letters and emails. This can also include things like the association's Facebook page, social media, text messages that board members are sharing either between homeowners and board members or board members and board members. I know some communities have like WhatsApp groups and perhaps some instant messaging. Um, Maria, is all of this kind of fair game when the association gets into court?
Yeah, and unfortunately, it could get kind of embarrassing because if you don't have a separate email account, then all of a sudden, we are in litigation and they're entitled to, on a broad basis, seek to look at all of your emails. The emails may or may not be relevant to the association, but they may ask for it and a court may order you to produce it. Something else that has been weighing on me recently in terms of association records is I've been seeing a lot more usage of AI in conducting summaries of association meetings. And I don't take issue with using AI as an assistant so that you have accurate minutes prepared. Like maybe you just forgot that a motion was taken or something like that. However, I think you should delete them Like if you are either recording it or you have an AI summary, you should delete those records because they are not part of the association's formal corporate records, which are the minutes, and only the board gets to decide what is and is not the association's record and history. And I would hate to litigate a matter and have to argue why the AI's record is the one we should believe and not the HOA's minutes. So, I've seen that practice come into play a couple of times, especially with a meeting with their attorney. Because that's privileged, I mean, I would hate for that record to just get leaked because you should be able to freely have your conversations with your counsel and not have to worry that someone's going to read it and, take advantage of that information. So as far as association's administrative tools go, there are certain things at your disposal without having to file a lawsuit in order to resolve conflict or handle a dispute such that you don't have to escalate the thing to superior court because that would be time consuming and expensive for everyone. The first tool that you have at your disposal is called an IDR, which stands for Internal Dispute Resolution. That's a provision of the code where it allows for the parties to meet and confer on an informal basis. And to the extent you guys come up with an agreement, then that agreement is enforceable in court by statute. I like this tool if the dispute is not necessarily a violation context, but maybe it's more of like a people just aren't getting along and it's really taking up too much time and energy for the association. Or it could also be used as a really good tool for an intermediary step, such that, if you have something going on either with a board member and the association or, two members or something like that, and it's kind of bubbling up, I like to use it as a way to document a step that we've employed to allow for the parties to try to work it out informally. It's always good for courts to see that parties are trying to work it out without complaining to them. The next administrative tool that you have at your disposal are your violation hearings. Oftentimes, what the complaint will be is that the association didn't do something, right? And so maybe technically the complaint is just bad enough that you have a violation hearing, but not necessarily so bad that you're going to sue a particular member. I think it would really make sense for you guys to follow your own enforcement policies and use your administrative tool of conducting a violation hearing because you do have a duty to investigate. You don't have a duty to do whatever other members tell you, but you can at least show a proper record that you're following your own enforcement policy and investigating complaints as they are received. The third tool, which is a little bit more expensive and a little bit more involved than the prior two, is mediation. So before filing a lawsuit, the association is obligated and all members are obligated to participate in alternative dispute resolution. The ADR that I like to use the most is mediation because I just don't like arbitration. I think it's in my humble opinion, it's a waste of time and it's expensive. And I don't think it does anything for anybody to waive their right to appeal or have a jury if they want. A mediation is where you submit your dispute to a third party neutral, usually a retired judge, and it allows people the confidential forum with a professional to help you parse out what a potential resolution may look like. Sometimes what the parties need to hear is from a retired judge saying, hey, what you're complaining about is BS. And if I was the judge on your matter, I would tell you that, and then it would be a lot more expensive. So maybe you should resolve it now. Matt, have you seen any of these tools be used in a successful way?
Yes, absolutely. I mean, I think the goal here, right, is bringing the temperature down, and I found that bringing people, especially, on Zoom or in in-person hearings, can really humanize the whole process a little more, instead of just kind of sending letters back and forth that may be very cold and impersonal. So, for instance, we've had communities where there are noise disputes between owners who are in the above unit and the below unit. We've been able to successfully bring them together and one, talk to them about like kind of what led to this and the various things that are at play, and then come up with a solution that worked for both parties without having to engage attorneys and do a bunch of other things. There was this thought, right, decades ago that there are some things that are primarily they're just a homeowner to homeowner issue. We don't need to get involved in that. The corporation is out of it. As Maria mentioned, there are fewer and fewer things that are falling into this homeowner to homeowner dispute category, and the burden to at least investigate, right? Not necessarily to take action if there's no action to be taken, but the duty to investigate does fall on the association. So if someone is lodging a complaint, the association can't just kind of ignore it, right?
There are a few subjects that we consider to be sensitive, and if the particular issue falls in one of these categories, it would be worth it to involve counsel early on, just because they have the characterizations and more likely than not ripen into something bigger. Maybe not necessarily a lawsuit, but maybe something involving a regulatory agency. So the first one that may involve a regulatory agency are, the fair housing disputes. So if there are allegations of discrimination because maybe the association didn't make a reasonable accommodation, or just because they say they're being unfairly treated, that is a sensitive subject that would be worth it to involve counsel early on in. The other category would be assessments and collections. People owing money, it's sensitive. People don't feel good about it, and it has a very high likelihood of ripening to litigation because, for whatever reason, sometimes debtors feel like it's unfair, or, it's sensitive. It's sensitive for them.
Maria, does that include emergency special assessments?
All types of assessments, okay? Emergency assessments, special assessments, regular assessments, reimbursement assessments. Just owing any type of money to the association is just frankly not fair. And it's a really different respect that assessments get than taxes. I just had to post a tax payment today, and I did not complain. I just paid it. But, people don't have the same treatment of HOA assessments that way. And assessments are a form of violation, but there are other types of high profile violations that are also sensitive, particularly architectural. I would say architectural violations are very sensitive. And, for whatever reason, again, people will get a permit, but they will not get HOA approval. And then when the HOA comes back and says, hey, you didn't get approval for this, we don't get the same treatment that the local regulatory agency or city or county gets when they process permits. So that's also a little bit more of a high profile violation. Let's see. I think we also identified repair issues. Also, just because someone threatens to sue, it's not always idle. Sometimes it is coupled with a lawsuit, but just way down the line. I think we flagged that as a sensitive subject just because insurance companies are being more and more hawkish around when you let them know when something is a potential claim. Not that you're opening a formal claim, but they are writing into their policies and really hanging their hat on the fact that maybe Joe Schmo said at a meeting 3 years ago that he was going to sue, and then years later he did. They'll say something like, well, there you go. You didn't let us know. Even though he was,
Especially if you put it in the open meeting list.
yeah, exactly. Even though he was just mad in the moment. There's another reason why I should delete those AI notes, by the way, because they may not agree with your corporate records. The last bullet point that we have as a sensitive subject is political outbreak and insurrection. We kind of say that tongue in cheek, but what we mean by that is, we can relate back to talking about how boards should be a team player, but sometimes it's just, team A versus team B, and there are two factions that are trying to claw control of the board and do certain things, or there's a committee of people that's fighting the board for something else. So, that very easily informs us that, okay, this is going to be sensitive, and we know it's not going to be a relaxing time with the membership, and it's possibly something that requires more care and attention.
Absolutely. So, to wrap things up, a couple of tools that we talked about, communication. So, working on getting everyone's buy in, mostly, right? So, you don't have to have full community consensus on every decision that's made, contrary to some popular belief. The board of directors does have pretty broad decision making authority. The importance is just in making sure that you are communicating frequently, that recognizing that more information is better, and always explaining the why behind it. Documentation. So keeping your ducks in a row. You want to be sure that if you're ever presented with a records request, either by a member or by an attorney, that you have kept proper records. And just as a final reminder, bear in mind that most of your written records are going to be discoverable if a lawsuit is brought. And if you have not kind of segregated those from your personal correspondence, that may be read aloud as well.
Okay, and as far as administrative tools, do the deep dive and drill down on everything in terms of process, procedure, and what you do. You have several tools at your disposal, and it's worth it for you to employ all of them because you can get rid of a lot of disputes without having to do any kind of litigation, and you can avoid a lot of litigation coming from other people just by, as Matt says, humanizing the process and making sure we're all just talking to each other because we're all just neighbors. As our final point for you, and just to wrap it up, we identified for you several sensitive subjects. There are lots of moving parts. There are a lot of issues that come up where, it would be worth it to employ your corporate counsel as part of the conversation, only because they have a higher likelihood of litigation.
Well, thank you everyone for coming today, and we hope you're having a wonderful ABCs of HOAs, and we will talk with you soon.
And there is nothing else I would rather do on this Saturday than watch us.